All right, can everybody hear me? I'm going to walk around and be down here because apparently I have to be energetic and all these things now that Brian has said it. But then also I can see what's on the slides and actually see what I'm supposed to be talking about. So we're going to have some fun today. We've got a lot of things to cover. I'll try to touch on things at a high level, but then also give you a little bit of detail about what's going on. I don't want to drill down into the weeds of what's actually happening in Washington, D.C. You know, as we say, you don't want to know how the sausage is made. You don't want to know how laws and regulations are made. So we'll try to keep it high level, but please ask any questions that you want to. I'd rather talk to you about what you have on your mind and what you need to hear as opposed to what I've got on my slides. Hopefully what we've got on the slides here is going to cover what you need to know, but please feel free, raise your hand, shout out, ask me questions, let's start a dialogue. I think that's going to be the best way to go ahead and do this. What we're going to do, we're going to talk a little bit about Washington, D.C., regulations, legislation, what's happening with the current administration. Is it good for clubs? Is it bad for clubs? What's the forecast? And us in Washington, D.C. are great at predicting things. Just look what happened with the election. So who knows what the forecast is going to be, but we'll take a stab at it. And then also, I want to do a little brief status update on private status. There was a court case in Massachusetts, tough for me to say, that just came down at the end of May that I wanted to bring to your attention and talk about that. And some of the things that you have there, the handouts that were placed at your seat during the break, we'll go over those as well. But let's go ahead and get started. But I do want to say, when I received a call from Beth Sargent to invite me to come be the keynote speaker for this meeting, I have to say it was one of the most unusual invitations that I have ever received. And like Brian said, I get the chance to speak a lot and all across the country. And the invitation started by Beth saying, "You're there in Washington, D.C. What do you think about free speech?" And I said, "Well, free speech, it's what makes our country great. It's the First Amendment. Absolutely, I'm absolutely for free speech." She said, "Great, I need you to come give one at Ocean Reef." So, that is what you're getting right now. You're getting a free speech. So, and I was glad. You get what you pay for. But what I like to say is I do work for the National Club Association, and I've been working for associations for probably about 15 or 20 years now. Never knew anything about associations before I happened to fall into a job at CMAA a couple years out of college about 20 years ago. And what attracted me to associations was the fact that I get the opportunity on a daily basis to help people or to help businesses in their day-to-day functions of their operations, or at their business or at their club or some of the other things. And to me, that was amazing. I was able to provide great customer service. I was able to make connections, interact, build relationships. The same things that you do with your members. I was able to do that for members of my association, the various associations that I've worked for. But the one thing that is constant, whether it's at a club or it's at an association, we need people to be involved. And as President Roosevelt said nearly 100 years ago, it's imperative for people to get involved with the association that protects their industry. Because yes, we're in Washington, D.C., but we're not going to be nearly as strong, as effective, if we only have 10% of the industry who is members of us. A couple reasons. One, financially, yes, we don't have the resources to be able to do a lot of things. Two, we don't have the stories. We need to be able to go up on Capitol Hill and talk to Senator Rubio or Congressman Cabela or whomever and say, hey, we've got this many clubs who belong to our association that we represent. But more importantly, they present this they have this much of an economic impact in your district or your state. They employ this many people. That's what it is. And then it's the stories from people that we can give to the congressmen or senators and say, this is what's going to happen if this legislation passes or if this legislation doesn't pass. It's going to hurt people in your district. You know, a great story that has often been told in our industry from Brad Steele. He was talking to Congressman Charlie Rangel from Harlem, New York. And he was talking to him, and Congressman Rangel said, I don't have any private clubs in my district. And Brad said, that's true, you're right, you don't. But you know what you do have? You have people who work at private clubs who live in your district. And those are the people that we're representing in the clubs. So it does make a difference. So this will be my little sales pitch. And again, Brian, I thank you. Appreciate one for Peacock and Lewis joining and becoming a more and more active member of the association. And this is my little sales pitch. I will ask you to join. I know there are a good number of members here. Those of you who are not, I do strongly encourage you to take a look at what we can do for you as an association, and also more importantly, what you can do for us and what you can do for your industry. All right, so who is National Club Association? We are the only association that lobbies on behalf of the private club industry. And it's funny, anywhere outside of Washington, D.C., the word lobbyist is a 4-letter word, as well it probably should be. In Washington, D.C., it's an absolute necessity. And it's Brad Steele, who I mentioned earlier, who is our Vice President of Government Relations and our General Counsel. I always kid him. I say, when you introduce yourself to people, do you introduce yourself as a lobbyist or a lawyer? Because neither one of those are fun. I don't think anybody's going to want to talk to you. But again, it's a necessary evil that we have in DC. And so that's what we do. We also provide insight, what's happening in trends in the industry, and a lot of governance information. How are clubs being run? How should they be run? What's the proper way to have boards and committees oversee your clubs? So on the advocacy side, not only are we lobbying on Capitol Hill, we're meeting with congressmen, meeting with senators, we're also looking out to see what's happening on the regulatory front in the agencies. And we'll get into it, and we'll see over the last couple of years, that's where most of the action has been happening because it's been so stagnant in Washington, D.C. So they have had to resort to the regulatory agencies making rules to try to implement some type of legislative change. Also, in the state houses, what's happening in states? NCAA is getting more and more involved in state legislation whenever we can, because we know that a lot of politics is all local, as they say. And so there's a great example in New York. There's bills being introduced to change the way that property tax is allocated, especially for golf courses. So we're getting involved in that. So again, on the Hill, in the regulatory agencies, in the state houses, as well as the courthouses. And then that's the court case from Massachusetts that we'll talk about in a little bit. Insight, the Club Trends magazine that's on your desk in front of you, the publication that we do quarterly with McMahon Group, enables us to provide the information to you, to our members, of what is happening in the world, what's going to be coming down in the next 6 months, the next year, couple years in the private club world. A lot of case studies, but a lot of this is what's happening, not necessarily in the private club world specifically, but what's happening in food and beverage trends that are going to affect the private club industry. So that's what that covers. And this issue is one we devoted to just golf. And there's a very interesting story in there about Medina #2, how Reef Jones came in there and made it their Links for Life course, where they modeled it after the longleaf tea program in North Carolina, where you put multiple tee boxes on every hole, so that whether you're a very beginner, young person, whether you're a beginner who's middle-aged, or whether you're an older person who's played golf but just can't hit it as far, you have lots of different opportunities to play that hole from these different tee boxes. And over the weekend, Reef Jones just opened up the course at Medina. We saw that. So that's a thing, again, where we're seeing trends that are happening, especially with golf, making golf more accessible to people for their entire lives, as opposed to people who can only hit it 400 or 500 yards. And then the governance. Also, one of the handouts was a privacy checklist. We'll look into that. But we provide information with our club director reference series, our club governance standards. What are the proper ways that you should be governing, or your club should be governed, and what should the board of directors be doing? Again, we're trying to get it so the board of directors is doing their role and not the role of the manager. They're not looking into the day-to-day operations. They're not looking into what's the cost of the cheeseburger, the hamburger, why are we giving away goldfish at the bar. That's not the job of the board. And so we try to really lay out what specifically boards should be doing, and doing it in the right way. All right, but as we did say, we had our National Club Conference in New York a couple weeks ago. I think everybody's going to notice a couple of folks here with Mr. Eric Trump. We had Bernie there on the left, and then Brian and Julie on the right. And I like the photo on the right. I don't know if everybody can see, but even though that Brian is talking to the son of the President of the United States, Julie is still just staring at Brian. She doesn't even care that that's Eric Trump. She's just so enamored with Brian. I love that. That's a great time. So this was a good success for us. It enabled us to reach out to the leaders in the industry, have some people there to really understand who National Club Association is and what we do. We'll be in Los Angeles April the 16th to the 18th next year. Hopefully you'll be able to join us. All right, so Washington, D.C. It's not that bad. I'm not that boring that I'm looking at my own watch to see when I'll end. I just want to make sure I get you guys out of here on time. Washington, D.C. Did a picture of the entire city because the things that are happening right now aren't on Capitol Hill, they're not in Washington, they're not in the White House, they're at the regulatory agencies, which are between those, that whole green area right in there. And that's what we're going to talk about, regulatory issues. You can say a lot of things about this administration since it started in January. Yes, that's not how most people would start a new administration, but the one thing that has been good for us that probably hasn't been talked about enough is the fact that there's been a lot of successes on the regulatory side. And this is very good for our industry, and we'll get into that. One of them, executive order. So the president said any new regulatory regulation that is proposed, you need to remove 2 of those before that new one can become law, which is great. And this happens other countries. UK is a 3-for-1, Canada, Australia are 2-for-1. So it's not unprecedented to do this, but it is unprecedented to do it here in the US. And so that's a very good thing, because I think we can all agree there's way too many regulations on way too many things that's stifling growth and stifling the opportunity for us to become more successful in our businesses and in lots of other businesses. The Congressional Review Act. This is an act that enables Congress to look at a regulation that comes down from an agency. And if Congress doesn't like it, whether they think it's gone too far or whatever, they can vote against it. And then it goes to the president, and the president has to sign this. This is never going to happen other than this unique time right now, because a lot of regulatory regulations came down right at the end of President Obama's administration. And so there's a 60-day window that Congress has a chance to look at all new regulations. And so because they were coming down from the Obama administration, the Republican Congress looked at them, they didn't like them, they sent them to President Trump, and he signed them and said, yes, these regulations should not go into effect. Normally when regulations come out, they're going to still be under that same president, and the president is not going to sign anything from Congress that takes away a regulation that he had one of his departments put in. So that was very good for us, especially, again, got rid of a lot of regulations we thought were unnecessary. And then Mick Mulvaney, former congressman from South Carolina, someone that we support, that National Club Association supported when he was running for Congress and donated to his campaign. He's a friend of the industry. He's now head of the Office of Management and Budget, and he will make sure that regulations, not specifically just for our industry, but for any industry that are overly burdensome, do not go into effect. So that's good. Another thing we've got potentially coming down, the Regulatory Accountability Act. This is passed the House. Basically, again, makes it easier for the rules of Supreme Court ruling, which would require the courts to look at a department, whether it's Department of Labor or Education or so forth, their regulation, and give them more deference. And that's something that we always fought against, because these regulations are being put in there by unelected bureaucrats, and we thought that they were giving too much access and too much power to be able to make these regulations. So this act does that. Again, limits the size of it, and then includes more people of who it's going to affect before it goes into place. A bill has been introduced on the Senate side that would correspond with this. We'll have to see where that goes. But again, if all the things that are happening, do take some solace in the fact that regulations and the regulatory environment is better in Washington, D.C. right now, especially for our industry, than it has been in a long time. Now, a couple specific of those regulations. Department of Labor's overtime rule. We all remember this rule, where they were going to increase the minimum threshold for overtime from basically a person making $23,660 a year up to $47,000 or $48,000. So unless they made $47,000 a year, then they had to pay them overtime if they were working more than 40 hours a week. I mean, to be able to double it in one fell swoop was just tremendous. And so thankfully there was a federal court in Texas that did put a stay on the ruling, and so they did not go into effect. Again, this was supposed to go into effect November 1st. And what we've seen now is that the new Secretary of Labor, Secretary Acosta, is formally going to remove the rule, because that rule is still into effect. The judges just said, okay, we're putting a stay on it or a stop on it right now. And so we've got to formally remove that rule. So we're doing that. But then the secretary, during his confirmation hearings, said that he would be interested in looking at some type of increase, to that minimum threshold, which again, we think is fine. We can work with that because, $23,000 a year is probably a little bit less, or probably a little bit low, to say somebody making, $24,000 doesn't deserve overtime for more than 40 hours a week. So we will work with the labor secretary to come up with a potential, middle ground, maybe even a phase in of that. One of our biggest issues was the fact that it just immediately overnight jumped 100% on that. So that's something to continue to be looking out for, but what we'll update you on as we continue to work with our coalitions and what's happening with that. But one of the things that the overtime rule did not address, but that is still into effect, is the white-collar exemption. So, okay, somebody makes more than $24,000, that does not mean they're automatically exempt from overtime. They still need to fit into one of these three categories: executive, administrative, or professional. And so if they fit in one of those categories, then that's good. Then that's fine. Then they will be exempt. But if they don't, and even though they are still making more than that, they are eligible for overtime. So make sure that you work with your human resources directors, your staff, to see if they do fit in one of these categories so you can classify them properly as if they are an exempt or non-exempt employee. And the highly compensated employee, for making over $100,000, you just need to meet one of those qualifications in one of those categories, and then you would be considered exempt from overtime. Waters of the U.S. This was another regulation that came down during the Obama administration. Thankfully, we were able to get a court to stop it. But basically what it did in plain English made almost every body of water a protected body of water. So you had to get permits if you're going to use any type of fertilization on the course that would flow into the body of water. Then the problem is they didn't define what a body of water was. Could have been a puddle. Could have been a stream that came after a big rainstorm. We've seen a lot of these. So there was no definition really of what it was. The Army Corps of Engineers even didn't want to be associated with this. So thankfully it was stopped by the federal court, again in Texas, thanks to our friends in Texas, but that's where everything gets, court cases are filed there because pro-business, pro-growth community knows that it's a more favorable environment in Texas to be able to do that. So that has stopped. We are working with the secretary to meet with them to say, okay, well, what can we do to make a rule that is good for the environment? Because again, we're not looking to be harmful to the environment. We're just looking to be the best stewards of the environment, but also in a way that makes it possible for us to run businesses effectively and efficiently and not be overburdened by the regulations and the costs that are coming down from that. So as we are meeting with them, we're going to have a say. The private club industry, National Club Association, is going to have a say as to, okay, what should be a good rule for that and what makes sense for our industry. Another fun one, employee classification for independent contractors. The Department of Labor, and not through one of their regulations, but through looking at a bunch of different court cases, came up with their economic realities test. They say, okay, well, how can we classify who is or is not an employee or independent contractor under the Fair Labor Standards Act? And so this is what they looked for. Work performed, is it an integral part of the club's business? Does managerial skills affect his ability to make a profit or a loss? What are the relative investments in each business by the club or the worker? Does the worker require some skill or initiative? How permanent is that relationship? If somebody's been caddying as an independent contractor for 25 years, that's a pretty long relationship, pretty permanent. And then how much control does the club have over that person? So what they did is, so Department of Labor said, okay, well, we've now got these six factors that are in this test now. So Department of Labor can go out and they can look at businesses and say, well, how are the businesses working in relation to this? And no single factor, not one of those. It was all six of those that they had to meet. It wasn't you could just take one and say, okay, well, I meet one of them. It was all six that had to be met. But the new Department of Labor, again, regulatory action that's happened in this new administration, which has been good, they took away the Department of Labor's guidance. And so what that means is the Department of Labor is not going to come knocking on your door and looking at your employees or independent contractors and using this test. But what the problem is going to be on the court cases. And that's where people will say, a disgruntled employee, former caddy, whatever, is going to go and file a suit and says, well, I was misclassified. I should have been classified as an employee because of all these things in that those six factors in that test. In a couple cases, in Florida, Stream Song, that was settled, so we don't know how that came out. And there's one going on in New York right now, Garden City Men's Club, where a caddy is suing the club because he's saying, I should have been classified as an employee of the club because of all these things. And so depending on how that case comes out is going to be huge in determining all future cases and future decisions for the private club industry. So we will keep you abreast as to what's happening there. And it's interesting when you talk to both sides in that they think, each side thinks that they're going to win and they've got the better of the case on it. So it will be interesting to see what happens with that. Like I say, that's going to be really determinant on how we move forward on this issue as we move. Yes, it was. Yes, sir. So what potentially can you do? And we at NCAA are right now in the process of working with the Western Golf Association to put together a white paper on independent contractor classification for caddies, because we want to put out all the facts out there, have case studies, and then leave the decision up to you as to what to do. We're not going to take a stand on what you should do as a club, because that's up to each individual club. Every club's run differently. They have different rationale for doing something. But what we're going to do is we're going to lay out all the facts for you and let you decide. So like, what if you said, okay, well, I want to make them independent, or I want to make my independent contractors employees. What is that going to do? Well, it gives you complete control over their work. It's something that the members expect, that these people are employees and that they should be there when a member drives up and needs a caddy. The kids who are kids who are service caddies can be expected, they can be the employees. And again, the members still pay for this service. They're just paying the club much like they would if they were getting a cart. And the caddies can be tipped employees as well. So you can do that. Or if you want to say, no, we want to make sure that our caddies are independent contractors and we want to keep them that way, well, then that's fine. You just need to educate the members on what they need to do to make sure that you're following those rules and regulations. Tighten the any contracts that you have with caddies to make sure they know what's going on. And one of the things that we're also doing is we're revamping our independent contractor classification monograph that we have as part of our club director reference series. And we're going to be including in their standards for independent contractors coming onto property. It's not going to be specific to caddies, but it's going to be specific to any independent contractor who comes onto your property of what they need to meet or don't meet. So at least it's a starting point where, okay, we want them as independent contractors. We can't tell them, exactly what they can or cannot do, because then that's taken away, obviously, their ability as an independent contractor. But what you can do is say, well, we're using these standards that were developed by the National Club Association for any independent contractor who comes onto our property. So at least gives you a starting point to how you can tighten those contracts with those independent contractors. Or a third option is the outsource to a third party, so you don't have to deal with whether independent contractors employees or not. Again, we're not recommending one over the other. We're just going to lay out all the facts as to what the options are for you, but then also let you know, if you're not doing things properly, then that could create some type of issue down the line with somebody coming back, in a lawsuit on that. National Labor Relations Board. This is a group in Washington, D.C. that hopefully and we think will become much more, not even pro-business, but just less anti-business, because there are 3 people from the president's party on this panel, 2 people from the opposition party on the panel. So it's now going to be 3 Republicans, 2 Democrats. With President Trump, we do think that he's going to make it a much more pro-business environment. And what the NLRB mainly did was to make it a lot easier for employees to unionize. They really worked to help, with special things in terms of like the ambush election rule, where the unionization vote could take place within a week, not really give time for the employer to try to mount a defense about that. The micro-union rule, where there could be specific groups within a company or a club that could create their own union. They allowed for that. Joint employer ruling, where if you do have a independent contractor coming on, you've hired whether it's somebody from a fitness company or from a gardening company or anything, they come on and they have issues, then you could get sued as well, even though you were just hiring an independent contractor, because they were looking at it as, well, the club or this business, they're part of it as well because they hired these people. So it was very, very pro-employee and pro-union. We think that this is going to get it back to being at least a little more fair in terms of a neutral arbiter, which is what it should be all along. All right. Any questions on the regulations, regulatory issues on that? All right. So now let's talk legislative. So what's happening on Capitol Hill? Not a whole lot. That's the problem. So the regulatory stuff was the good stuff. This is sort of where we're getting bogged down on what's going on. Currently, 241 members, Republican members of the House of Representatives, 194 Democrats. There are 3 open seats right now. There is going to be a very interesting special election in Georgia tomorrow for an open House seat. It's a seat that Donald Trump won by more than 10% in the election. But right now the race is too close to call. So it's going to be interesting to see how that comes out. Because this is, the Democrats are looking at this as, okay, well, if we win this race, then that really shows that people are fed up with President Trump. It's a referendum on him. And so they're starting to get momentum, and they think that could carry momentum into the 2018 elections, yes, which we're already talking about in Washington, D.C. Or if the Republican wins, Republicans will look at it and say, yes, everybody's happy with the way things are going. They want to keep the change that's happened in Washington, D.C. This is who we want to win and continue. So look for that just sort of as a, interesting. I don't think it's going to be, one way or the other in terms of, who wins and how things go. But it'd just be interesting to see how that race turns out. And what should be a relatively comfortable win for the Republican Party, it's a much tighter race right now, and it could actually end up being a victory for the Democrats. So that's what you have. But right there, the last bullet, so Republicans can only lose 23 votes in order to pass any legislation that they want. So just remember that as we move forward. On the Senate side, very close, 52 Republicans, 48 Democrats. Everything's split there. We thought we learned in our civics class in grade school that you only needed 51 votes to pass something in the Senate. Obviously, with the filibuster rule, you need 60 votes to get something to the House, then to be able to pass it. So 60 votes is the key threshold to get anything done in the Senate. And right now, Republicans don't have 60. There's also not 8 Democrats who are going to side with the Republicans to come over and get them over that 60 threshold. So the Senate's sort of in a stalemate right now until the 2018 elections. Again, already looking towards those, where there are going to be 25 Democrats up for re-election, which is a large, large number, only 9 Republicans. And so that is a situation where, and again, between now and next November, that is 3 lifetimes in terms of politics and what can potentially happen. So we don't know, can't count on something happening there. Who knows what the economy is going to be at that time? Who knows where things are going to be? But on the Republican side, they're looking at, okay, well, if we can basically just get to November 2018, we can pick up hopefully 8 more seats, and then we'll be able to do a whole lot of stuff. But then you don't know what might happen on the House side. Who knows what it's going to be? So that's where we are in the Senate, and that's where things basically just come to a place, they're stagnant, and they just die because nothing's really happening over there because they don't have the votes to be able to get anything done. But we have had a couple good legislative pieces of news. H-2B visa. How many people here use the H-2B visa program? Absolutely, perfect. This is great news for you. The 66,000 cap, very small. Unfortunately, I think the first day applications are in, everything's filled up. So what we've been trying to do is a couple things. One was the returning worker exemption. This was a bill that would say, okay, well, if you've come into the U.S. on H-2B visa before, in the last 3 years, then you can come back and you would not be counted against that 66,000 cap. So in effect, you're almost tripling the number of people that can come in on an H-2B visa. Working with the different offices, basically that language had to be trimmed down to 1 year if we wanted to get that language passed. So we said, okay, we'll take that. So we'll say, if you came in last year on an H-2B visa, you can come in again, not count against the cap. So you're doubling the cap. So that's good. That's good movement. And again, that's us working with the different offices to show, hey, this affects our industry. It's the workers. This is what you need to do. And from that, in the 2017 funding bill, they did have legislation in there that said they could increase the $66,000 cap if necessary. What those definitions are sort of have to be seen by the Department of Homeland Security. But more importantly, because of that and things that we're working on, we think into the 2018 funding bill, which theoretically should be done by October for the next year. But again, they're in Washington, D.C., they've never passed a bill. when it's supposed to be done, especially a budget bill. But at least it looks like the momentum is getting there for language to include the returning workers exemption in there into that funding bill, which will at least open it up a little bit. We still have a lot more work to do because we know a lot of people rely on that. And so, yes, that is a good sign of something that's happening. And again, that's not a partisan issue. I mean, I think anybody can realize, if they've got employers in their districts and in their states that need more workers, this is a good way to be able to do it. So that's good. All right, now the fun stuff. Tax reform. What is happening with tax reform? That's the interesting question. President Trump, submitted his plan of what it would be, and then it basically died right there because there wasn't a lot of detail to it, wasn't a lot of strategy into the plan. Main thing was, let's get the 7 rates down to 3. And then let's also be able to have, individuals who own companies, they pay themselves, let's, get that down as well. Repealed some other taxes, increases some standard deductions. So that's what President Trump wanted to do with his tax plan. And again, we think any tax plan that's going to put more money, back into people's pockets and businesses' pockets is good for the economy and good for our industry. So that's where that is. But that ties into the American Health Care Act, which is the reaction to the Affordable Care Act, or Obamacare as we know it. So we know the House passed the American Health Care Act, 217 to 213. Remember a couple slides ago, we were just talking about how the Republicans had 241 people. So let's see, 241, 217, carry Nate, move something over. That's about 24 people that they lost. Republicans lost 24 of their own members on a health care bill that was supposed to be their signature item. So that's pretty telling about how difficult it is to get something done in Washington, D.C., especially when your own party can't come together and support legislation that your party's president wanted to get done. So that passed. The one good thing that was in there is the employer mandate is taken out. And that's where it says that if somebody works 30 hours a week, they're considered a full-time employee. Everywhere else, it's 40 hours a week. Seasonal worker, seasonal employee. There are 2 different definitions for that for the exact same person. So very confusing. And then a lot of other regulations in terms of looking back as to how many people did you have working over a certain period of time. Again, a lot of regulations that just make it more difficult to run your business. So we're excited that the employer mandate has come out of that bill. There's a lot of other things dealing with the bill that make it a lot more complicated and why Republicans didn't even vote for it. But for us, that's the critical part of it. So that goes over to the Senate. Hold on one second. Apologize for that. Okay, so that goes over to the Senate. So now what's the Senate going to do with this? Senator Mitch McConnell, the leader of the Republican Party and House, the Senate Majority Leader, said that he was looking to have a vote on health care by June 30th. That's not going to happen. A couple reasons. One, the Senate doesn't even have a bill yet to vote on. 2, once they do get a bill, they have to send it to the Congressional Budget Office so they can what's called score the bill, so it can determine how long or how much it's going to cost, that bill, how much money it's going to bring in or how much it's going to cost the taxpayers. That's going to take 2 weeks. So right now we're past the June 30th deadline. So we're looking at, then they get a week off for July 4th. So then you're coming back, you're looking at mid-August or mid-July to late July before they can really even start looking at this thing, anything to do with it. But then also, Senator McConnell said that he will not bring a health care bill to the floor of the Senate unless he's guaranteed 50 votes on that. And again, we saw on the Senate side, there's 52 Republican senators. So if they lose a couple, if they lose 3, then he's not even going to bring it to the floor. And you're probably saying, well, you just said it has to have 60 votes. How can this pass with just 50? Well, because this is part of reconciliation, because it deals with tax language, because the health care bill had some tax issues in there. That's how it can be done with just a 50 vote. Again, part of reconciliation, part of what makes Washington, D.C. so confusing on that. So with that said, it's going to be very difficult to get anything done on health care. And besides, whatever the Senate does on health care, it's going to be a completely different bill than what the House did. So if the Senate passes theirs with 50, and if it's a 50-50 tie, then Vice President Pence will break the tie. So they'll have their bill. Then it'll go back to the House, and it's going to be two completely different versions. So then you're going to have conference and figure out, okay, well, what can we give and take on these, on these two bills to try to get it done. So again, this is how the sausage is made. It's not very pretty, and fortunately, it's a long process. So I wouldn't get our hopes on seeing anything happening until at the very end of July at the earliest on this. And then the good news is Congress goes out for the entire month of August for August recess. So then, now we're looking, okay, now we're moving things into September. I know, exactly. I know. I think it was a week or so ago, there was about 40 days left in the legislative year before the end of the fiscal year. And that included their month of vacation that they get to take, plus they get the week at July 4th and some other times. So they're not there really burning the midnight oil, for us. So that's where we are with, with the health care. And then that ties in with the tax reform. And so they also said, okay, well, what can we do with tax reform? How can we get something done on that side? And this is where actually it's working like it's supposed to. The House and the House and the Senate leadership are working together and basically saying, let's craft one bill at the start, and then let's put that through both chambers as opposed to two individual bills and then having to go through a conference and all of that. And so one of the things that we are seeing has been a way to be able to pay for all of those deductions and lower taxes is that this would remove the state and local taxes deductions that people get to take, which is about $130 billion each year that the federal government loses on that. Some things that have been talked about, again, this is the president's plan, hasn't been very specific. Nothing is very specific, a lot of vagueness in it. Other tax breaks, but what are they? Other ways of increasing revenue, what are they to offset this? So we don't really know yet. So what we do know is that the House and the Senate sides are working together to try to come up with something. We think, overall at the end, it's going to be lower taxes for people and businesses. They might lose some deductions, but you might get bigger breaks in some other places. But tax reform is something that's not going to happen until September. Again, when they come back from the August recess, if it does at that point. So don't go home spending. Don't go home and start spending what you think you're getting back in tax reductions just yet, because it's not coming for a while. All right, so that's what's happening in Washington, D.C. on a regulatory front, legislative front. We've got a little bit more time. I want to just do a checkup for you guys on private status. And this is a question that we get a lot from members and from non-members because they have questions about this, of what do I need to do to be a private club or a truly private club. Just a quick show of hands. How many people here think that their club is a truly private club? Okay, good. So hopefully those same hands will come up at the end when I ask it again after we go through this checklist. One of the handouts that you have is the privacy checklist on there. Feel free to take that with you, look at it, compare it to what you're doing at your club. So again, and so why is this important for private clubs? Let's see, a private club runs on two tracks that enables it to be a little bit different than businesses. You've got your private status and your tax-exempt status. There's one, yep. And so you've got your tax-exempt status as a private club or your private status as a private club. We're going to talk about the private status. But both of these are very important to make sure that you still have that designation as a private club for some of the things that you may or may not want to be doing. So private club rights. So obviously, First Amendment, not only does that allow me to come here and give a free speech, but it allows private clubs, it allows individuals to not be discriminated against either through the Civil Rights Act or the Americans with Disabilities Act. So any place of public accommodation cannot discriminate against people based on those two things. However, truly private clubs do not have to follow the Civil Rights Act or the Americans with Disabilities Act. And we're not saying that you shouldn't follow them. We're just saying that you do not have to follow them. It's up to you, your club, your membership, as to what you want to do. But again, as a truly private club, you are exempt from the CRA and the ADA because you are not a place of public accommodation. So what's the Supreme Court said about this? Again, no one should be treated differently in a public setting. They should be part of a protected class. Who is that protected class? Race, color, gender, religion, national origin, sexual orientation. When a club treats somebody differently, again, if they're truly private, they have the ability to do that, whether it's a men's only club, whether it's a women's only club, whether it's a religious affiliated club. Whatever they want to do, they have that ability to associate with whom they want to. And so they can. But as long as they're a truly private club, they have the ability to say, okay, well, I don't need to follow these guidelines under the ADA or the CRA. Make sure that you're balancing that right to protect the First Amendment with the right for treatment for all. And then the question is the club a public or private entity? That's what everybody looks at when clubs come into situations like this. Two court cases helped sort of define, how do we know whether we are a private club or not? What does that? Both with the JCs and the Rotary, both where the local chapters were sued by women, and the court found in favor of the women, even though they said, well, we're private clubs, private organizations. What did the court say? The court said that you have no selectivity in your membership. They did not limit the size of their membership. They did not limit the participation by non-members. Non-members coming in using the facilities or doing whatever. Advertising of membership and openings at the club. And the club was being used for business purposes. So that's where the court says, okay, those two organizations are not private clubs. And so that gave us sort of a list of, okay, that's the basis and the start of this checklist that we put out there for you. So now, what does that mean? A club needs to have a plan and purpose of its exclusiveness. It can't just be random here and there. What is the exact plan for it? And then, extremely selective membership process. Limits the ability to access the facility to members only. Is it organized around the social interests of the club and not its business interests? It does not advertise. It's controlled by its members, and it's a nonprofit, tax exempt or taxable. So that's where you're getting, okay, what do you need to do to be a truly private club? A couple cases. Arizona Country Club, suit, a female member said they had a men's only grill. Said, I'm suing. This is discrimination. Club said, well, you can't sue us. We're a private club. But the judge said that they did not have a selective and exclusive membership process. They catered numerous events for non-members, and non-member events were advertised to the public on the internet. So the judge said, you're not a truly private club if you're doing these things. Another one, Long Island. Member didn't like or a prospective member didn't like the membership policy. And so the court said, yep, non-members regularly use the golf and tennis facilities as well as the pro shop for their services. And the club hosted and catered numerous social events for non-members, and some events furthered trade and business activities, not social ones. So again, the court looks at it and says, okay, you're not a private club. Washington State, same thing. 4 females sued because there was men's only tea times and men's only grill. They didn't like that. Again, the club came back and said, well, we're a private club. You can't sue us. We're exempt from the ADA or the Civil Rights Act. But no, the court found, again, pro shop was open to non-members' use. Non-members regularly used it. Membership open houses, flyers in the neighborhood, catered numerous social events for non-members, high schools, weddings, businesses. And so the result was the judge found it in favor of the women, $575,000, nearly $775,000 in attorney fees, and the club ended up having to sell itself because it didn't have the money to do this. Again, if they were a truly private club, they could have had the men's tea times, the men's only grill, whatever they wanted to do, but the judge found they were not a truly private club. And again, these states had the same civil rights acts, but again, the states also exempted all of these clubs if they were truly private. And again, a discrimination case can only succeed against a public entity, not a truly private one. So again, this is where you need to make sure that you're following the rules in case there are any type of problems or situations that you might get yourself into a case or a suit where somebody says, I'm suing you, and you say, well, we're private. Are you really private? That's what you need to check. There are a couple good news. Not all the cases have gone against clubs. 2 that we'll talk about. Chicago Club, same thing. Someone sued because they did not comply with the reporting requirements under Title VII of the Civil Rights Act. That excludes private clubs. But the court said, again, club had limited use of facilities to members and their guests. Stringent membership process. Basically, it was a procedural gauntlet, is the quote that the judge used. And the club never advertised for members or to promote its facilities. So the court said it's a private club. They are exempt. This was a nice quote that they had, basically slapping the EEOC on the wrist by saying, in hopes of altering the playing field for all private clubs, the EEOC decided to go after the biggest fish in the pond, and in the process, it diminished its reputation and needlessly squandered both its own resources and those of the courts. So that's pretty good hand slapping by the judge for the EEOC coming and bringing that case. Now, this is the one that just happened May 31st, a couple weeks ago in Massachusetts. There was a member of the club who brought a guest to come and play golf. The guest was an individual who used a single-rider golf cart. And so he brought his own single-rider golf cart. And so he was trying to drive up onto the green to putt. And they stopped him and talked to the member and then talked to the guest. And the club said, we're not going to allow you to drive your single-rider golf cart onto the green. And again, we're not getting into whether it's right or wrong or they should or not. This is just facts of this case. And so this person said, well, you're discriminating against me against the ADA. Again, the Civil Rights Act we're exempt from, and the ADA we're exempt from, truly private clubs. And this person happened to be a former sportscaster up in Boston. So he had a lot of name recognition. He was friends of the media. So his first thing was he went to the media to say, this is what's happening, and they're not letting me on there. How bad is this club? And so the court came back in this ruling and said the club is actually a private entity and is not required to have accessibility under ADA because they said it was a selective membership process. The process was controlled by the members, voted on by the candidates, limited numbers that were there, and substantial initiation fees and dues. It also said there was no unfettered use of the facilities by non-members. I think there were 29 events, 23 when the club was closed. So again, you're hitting those points. You know, is there a limited number of access to members? Is there limited access to non-members for using the facility? And they never actively solicited members or promoted the use of its facility through advertising to the general public. So that's why the court found in favor of the club, because they could demonstrate, they could prove that they are a truly private club. What else? A couple of things here. Advertising, website, social media. In order to fall under those categories as a truly private club, you should not be putting things such as these on your website, where you're actively soliciting for members or actively soliciting for events at your club. And these are quotes off of clubs' websites. Again, that will right there say a good judge or a good lawyer will say they're not truly private. Look what they're doing. And it's right there on the club's website. So what should you do? Social media. You can have your Facebook, you can have your Twitter. Keep it closed, keep it locked. It should only be for members. If you have it on your website, you can have the front of the website, picture of the club, and then basically after that it's for members. So are you a private club? Public golf course has to admit everyone. Do you admit every single candidate who comes through your club? Now, there was in one of the cases where they did admit everybody who made it through the process, but the process was so grueling with one letter recommendation, then 2 additional letters, plus interview by the board and other things that the judge said, well, if anybody who makes it through all of that, yes, they're probably going to be admitted because there were so many places along the way that they would be stopped. Not a whole lot of people are going to go through that whole process. Are you a men's or women's club? Do you have gender-specific areas in your club? Again, you're welcome to do that as a truly private club. Again, what if someone alleges that you turn them down because of race, color, religion, gender, or sexual orientation? And there was a case in Connecticut like that. There was, clubs have been given the right to do things differently by the First Amendment. You need to protect that right. You need to do it the right way. And if you don't, you're jeopardizing the right that you've been given, and you're putting yourself and your club into potential harmful situations. So that's what I have. Happy to answer any questions for you on that, on the legislative, regulatory side, the private status side. Again, if there's anything we can do at National Club Association to help you as you're trying to, go through this minefield of what's happening, let us know. Reach out to me. I'll be here for the rest of the, through Tuesday night. Happy to answer any questions or sit down with you one-on-one about any of these things. But I do ask for your, support for what we're doing to try to make these things a little bit less complicated and easier, for you and for the private club industry. So thank you very much. Enjoy the rest of your time here.